Thank you so much, Hassan. And before I begin my presentation, I'd like to request the media team to put for me the ODPP mandate.
Hey there, cheki, naitwa Prosecutor Zawadi kutoka. Hey there, cheki, naitwa
I think Zawadi is playing a trick on me. Try again.
Naona nasema naona Omari hakupata court order, lakini ni kama amepata namna ya kuingia kwa hii machine zetu. It was just playing.
So, since Zawadi has, you ready? I go on.
Hey there, cheki, naitwa Prosecutor Zawadi kutoka ofisi ya Director of Public Prosecutions. Ukidai, the ODPP. We are Kenya's National Prosecuting Authority. Nasi hucheza kisisi, yani si who act independently in exercising state powers of prosecution and may prosecute criminal matters that are investigated by regulatory and investigative agencies such as the National Police Service and the Ethics and Anti-Corruption Commission, to name a few. Public prosecutions in Kenya zimekuwa zikiendelea kutoka zamo, yani madai za ukoloni. During the pre-independence era, public prosecution ilikuwa inapelekwa na riang na mabazu wa mtaa, yani village elders na colonial chiefs, na walikuwa governed by customary law. Si mnajua, during hii period, race heavily influenced decisions about whether or not to prosecute. During independence in 1963 and followed by the Constitution of 1969, Attorney General ndio alikuwa public prosecutor ule mso, na prosecutions in magistrate courts zilikuwa zinaendeshwa na police prosecutors. Wengi wao hawakuwa na legal training. Sheria ilikuwa ina change in tandem with the contemporary legal issues arising. There was also a conflict of interest. Juu prosecutors ndio bado walikuwa investigators. But all this changed in 2010 with the establishment of an independent office of the Director of Public Prosecutions under the new Constitution of Kenya. Finally, trained advocates kama mimi tulichorwa job kama prosecutors. Hii ilikuwa rada safi juu tulidevelop policy documents zenye zili assist in making informed decisions to charge. At the ODPP, our primary mandate is to exercise state powers of prosecutions and may institute, undertake, continue ama discontinue prosecution of criminal matters and all other matters relating to it. The DPP shall also perform any functions and exercise any powers prescribed by legislation in addition to functions and powers zenye zimepeanwa na Katiba ya Kenya ya 2010 and the ODPP Act. The ODPP also developed prosecutorial tools zenye zita-guide prosecutors waki-make decisions za kucharge na kuhelp kupunguza population ya jela. These tools are the National Prosecution Policy, the General Prosecution Guidelines, Guidelines on the Decision to Charge, the Diversion Guidelines and Explanatory Notes, and the Plea Bargaining Guidelines. At the ODPP, si ndio huamua which cases referred by the various investigative agencies should be prosecuted. Determine the appropriate charges to be preferred in all cases by advising the investigative agencies at various stages. Prepare cases and present them in court. Provide information, assistance, and support to victims and prosecution witnesses. Assist or guide in the investigation of a crime. Facilitate victims of crime and witnesses during prosecution. Contribute, develop, and implement policy, procedure, and law reform. Handle matters relating to international relations, including extradition and mutual legal assistance. Tukicheza kisisi, si huchunga interest za raia, interest za administration of justice, na pia huzuia abuse ya the legal process. Yani, si hudai kuprovide quality, impartial, and timely services kwa njia yenye ni professional, efficient, just na bado ni fair. Sindo the ODPP. Tunaahidi mashtaka yenye haki na usawa.
So that's Zawadi. Basically, Zawadi has just demonstrated the mandate of the ODPP and what we are expected to do under Article 157 of the Constitution. And I will not repeat what Zawadi has said, but I'll move to the structure of the office. So basically, we have the DPP at the helm, as the comms team is trying to bring up that bit of it, followed by the Secretary Public Prosecutions, who is the principal deputy to the DPP. And then we have an advisory board that constitute various agencies, that is the public service, and then the DPP chairs the board, the Attorney General, the Treasury, the Registrar, the LSK, Human Rights, Witness Protection. So that I know that earlier on during the DPP's presentation, you also alluded that we are also answerable to Parliament, and that is through Section 7 of the ODPP Act. We are expected to be submitting our report. So the board is basically to deal with the recruitment, so they're able to advise the DPP on issues of recruitment. But as you're aware, our office is independent. Therefore, the board cannot discuss anything technical except recruitment and attendant issues. So after the DPP and the Secretary's Public Prosecutions, we have 5 departments. The first department is Department of the Convention and Related Crimes. This is where we have the murder cases falling under. We have the SGBV. We have the penal code cases. And then we also have Department of Economic and Organized Crime and International Crimes. And this one of the most famous divisions is the Anti-Corruption Division. And our colleague will be taking you through what we do in that particular division. And then we also have Department of County Affairs and Prosecution Services. And this is a department that is able to connect us to the roots. We are able to follow up on what is happening on the grounds. And then we have the Prosecution Training Institute. Again, this is an institute that was established to be able to equip the prosecutors with various skills that is required. And then we have the Corporate Services, also known as Central Facilitation Division, or rather department. So allow me, as I'm making my presentation, some of the deputy directors are here. So maybe, as I mentioned your department, Mr. Mule, you should just wave so that you know that we are a team, and the deputy directors are here. And also the deputy director in charge of convention and related crimes, the deputy of the deputy of the deputy director is here, Madam Mauya. And then County Affairs, we have Mr. Mule here. And of course, the DPP is here. And then what happened when the DPP joined ahead? When the DPP joined in 2018, he noticed that there was no proper communication between the counties and the headquarters, and he created what we call the regional offices, and that's why we're having Mr. Hassan here. So the regional offices are 9 in number, and the main reason why they exist, yes, no. Five, yes, there we are. So the main reason why the regional offices exist is to be able to know what's happening in the regions. And so we have a total of 47 counties. We also have 47 prosecutors heading those counties, and a total of 139 court stations. So we realized that the 47 counties and 139 court stations were mini DPPs. We were not able to know what was happening on the ground. And given that it's important to be part of the community, the DPP created the regional offices. So what are our priorities as an office in the year 2021? I'll just take you through our priorities. And the first one was quality prosecutions. And with this, we saw our conviction rates, and I think we shared this in the previous annual report that we shared last year, that is 2017 to 2020, which the numbers arose. But we are currently, in this current financial year 2021, we are looking at general prosecutions at 93.32%. And that of corruption, because we tend to separate it, there's a focus on corruption cases. We have risen from about 30% in 30-something percent in 2017 to 68.18%. So we are seeing that quality prosecutions is bearing fruit. And also to ensure that we are able to deliver quality prosecutions, we've developed tools, and one of them is the decision to charge. Mr. Mule will be able to emphasize on that. But I will be focusing more on plea bargaining and how it has helped hasten or expedite cases in court. And so basically, plea bargaining is one of the policies where the accused persons and the prosecutions are able to reach an out-of-court settlement, then they go back to court, and then we are able to fast track that case. It has benefits in terms of saving the court's time, saving the accused person's time, and also declogging the prisons. Then we also have diversion. Diversion, we tend to use it mainly on children and related cases. Earlier on, you had the DPP of Uganda talking about 21st century prosecutions. And this is where we feel as prosecutors, it's no longer about just prosecuting, but we must make sure that those who are being prosecuted are also able to gain from the system. So when we divert, I can give you a case scenario of the children. If you get a child that is probably has abused drugs, we no longer just take them through the court process, but we'd rather divert them out of the system and collaborate with agencies or societies like Red Cross and have them rehabilitated. So that's how we are playing our role within the community. And then we also have deferred prosecution agreements. This is a hot one. And out of deferred prosecution agreements, we are able to reach an agreement with the suspects on condition that they are able to meet certain terms. And if they do not meet those terms, then we are able to prosecute them. A case in scenario, we had the banks, 5 banks that had floated various money proceeds and money laundering crimes act, and we were able to reach out of court settlements through deferred prosecutions. They were able to pay money, and we were able to put them on checks. So deferred prosecution is helping one in the sense that you're able to make sure that the governance systems are put in place. At the same time, the person is penalized if they fail to follow through with what is in the agreement, that we still have the leeway to be able to charge. So then the next area of priority for the office or the Prosecution Training Institute. I joined prosecution, I think, 20 plus years ago. And I remember the third day of my day in the office, I was summoned and given a very big file. And I was told, go to court. Those days we used to be given files by the clerks. And I looked at the clerk and I was like, you're kidding me, I'm not going to court with that fat file. We call them fat files. And it's like, sorry, it's been allocated to you. I can see Madam Owoya is smiling because the experience is probably similar. So I summoned my guts. You know, when you're young, you think you know everything. And I walked into the DPP's office, and I told the DPP, it was Madam Kidola, that, you know what, I'm only three days old. I'm not going to court with this matter. And she just laughed at me and tapped me on the back and told me that you can do it. And guess who was on the other side? The Orengos and the likes. I was like, I can't do it. But she just smiled. And in my naivety, I went to court. No experience, because we're not taught about prosecutions in law school. Neither are you taught about prosecutions when you're doing law degree. So then I went to court, but luck on my side, I was able to research and I got the conviction. But that was really a horrifying experience. So through this, when again the DPP joined in 2018, he was able to come up with the Prosecution Training Institute to mainly make sure that when the prosecutors are coming in, then they're trained. At least you get some induction. And I can confirm here that so far since he joined, the prosecutors who are coming in are being trained, and we've seen the impact. And you've seen some of them are here. You see them making presentations because of the Prosecution Training Institute. Then they've gained more confidence and more quality to be able, and expertise to be able to present the cases properly. The other area of focus is the proceeds of crime and recovery unit. So we are saying that it's no longer business as usual. If you've stolen somebody's money, if you've stolen the taxpayers' money, we are coming for your money. And we are trying to make corruption very unattractive, or any other commission of offenses very unattractive, because then we did a study and realized that criminals apparently sit down and come up with the risk assessment of, if I commit the offense, what are the chances? And half the chances they used to go like, I'll be in prison for 3 years, like theft is only 3 years. And after 3 years, I can come and spend my money. So when you follow the money, then it will be no longer attractive because you're denying them the very purpose of going to get that money or stealing the money. So then again, we are saying, as we are trying to develop the system, internally also, we must make sure that we are living to the expectations of Kenyans. So that's why we have the internal compliance unit. Madam Murungi is here. She'll be able to explain much about it. Together with the Inspectorate and Quality Assurance Department. Again, this department is to ensure that the decisions that are being made are consistent and the decisions that can stand the test of time. And then, of course, we are having the case management system that we've also allocated for time that we'll be able to discuss perhaps tomorrow. So those are our priorities. And then how are we moving forward 2020 to 2023? And we came up with the Excellence Charter. Again, the DPP alluded to this during his speech. And the Excellence Charter has 6 objectives. And I think I'd like Carol to play the Excellence Charter, the objectives, before I proceed. So the 6 objectives are, the first one is independence and integrity. And I am glad that when our DPP from Uganda was making her presentation, she also talked about independence and integrity. And we believe that this is very important for us to be able to move forward. We must be able to put the spirit of the Constitution alive. And I know that this issue of independence has really brought so many questions, especially in terms of making the decision to charge. And we are always going by what the Constitution provides, that it's an independent office, and we must live to the expectations of the Kenyans by being independent and persons of integrity. Then, of course, we're talking about the lifelong learning, that is through the PTI, and then the reshaping of the prosecutions. That is to modernize. Again, I gave you my example, 20 years plus. And now, and having had the benefit of walking through to the current situation, I can confidently say that we are more focused in being part of the community. In other quarters, they call it 21st Prosecution Service. In other quarters, they call it community prosecutions. And what we mean by community prosecutions is to go to the community, understand their issues, and be able to make policies that resonate with that community. So again, I'll give an example. In 2019, we were in Kayole, and we were told about the soups where people just picked up. No, sorry, it was touting when my numbers were like get into the Matasuit 5 bob, 10 bob, and then they'll be arrested and charged. And out of that, then the DPP was able to give directions, and we are no longer prosecuting such crimes. We were there the other day. We've learned that there's another one called Maeneo or idling, and I think the DPP has already given a direction how the office is going to handle such matters. So we are saying that you are doing community prosecutions, not prosecuting the community, but feeling them and hearing from them and making policies that resonates with them. Another issue we are still discussing is the issue of cash bail. Again, when we did our study through the All for Justice, we realized that there are some people who are not even able to pay 500 shillings to be able to be released on bond. So again, as a prosecution authority, we sat down and we wondered whether there's really justice if someone is not able to put 500 bob to pay the bail for 500, and then they end up being in custody. So I think the DPP is in the process of seeing how to engage the NCAJ so that the issue of cash bail can be done away with. So then the other issue we are looking at in terms of reshaping prosecutions is the issues, again, that I said earlier on, the diversion, especially for those who are abusing drugs. We are no longer just prosecuting them. And also for the mentally ill persons, we make sure that their mental health is taken care of. But the most important one is what I keep saying is the restorative justice. It's no longer retributive, but we are focusing on restorative justice, whereby we are able to make sure that the accused person is able to compensate the victim, as opposed to just going through the system and then the person is put in prison and you're still not getting back whatever you lost. So we are trying to emphasize on more of restorative justice as opposed to retribution justice. So that is just some of the examples on how we are trying to reshape the prosecutions by engaging the community and making sure that we are serving them as we have been called by the Kenyans to be able to. So then the other thing that we believe in is leadership. And through this, you've seen we've put in various structures so that the next person that steps in can be able to go ahead and go ahead with the mantle. So again, there is various mentorship programs that are being done within the office. We have a couple of prosecutors that have since been trained have been mentored in other jurisdictions so that they can be able to bring in the best experience. And also through this leadership, we've been able, although we are tasked to prosecute, we have been able to go to committee and mentor the children there. And even sometimes, I talked about the fine, have some of them released on bail, because then we believe that the children should be given a second chance in the society. So then the other thing is organizational effectiveness. This is done through our various systems, including case management system that we'll be talking about tomorrow. So what are the challenges? Just a few challenges that we encounter. So the first challenge is budgetary constraint. Like any other government department, we really have a big dream, but that dream must be lived in within the budget that we're being given by the parliament. So of course the budgetary constraint, we like to have more prosecutors so that we are able to move with speeds. But because of the budgetary constraint, we are not able to employ all, although I must admit that currently we're in the process of employing more officers to be able to be more efficient and effective. The slow judicial process, case in point is Okeme and Gishuru. I think when we first filed that case, I was barely 10 years in the office. And fast forward 10 years down the line is when the matter has not even, I can't even say that has been finalized, because this is now when we are beginning to start the journey of extradition 10 years down the line. So you're saying that the slow judicial process, but what again we've done through the DPP and the NCAJ, particularly in the corruption cases, we've been able to speak to the judiciary, the Chief Justice, and she was, or rather they've already given more magistrate to be able to move a bit faster with the cases. Then, of course, there are legislative gaps. Some of them we've been able to deal with through jurisprudential development. Case in point is Section 62 that talks about public servants and state officers. Public servants, you charge, you're told to step aside. State officer, you still remain in office. But through the leadership of the DPP, we've been able to develop jurisprudential, and we've had some state officers stepping aside. Of course, threats and intimidation to witnesses. Again, I have many stories having been there for 20 years. I had this very good case, and I was so sure of myself. And this I'm saying here because as media, we really like you to help us. So my key witness was the first respondent on the situation, and was a media guy. He captured whatever happened, and I was very excited because my case was almost what we call open and shut case. So we proceeded on well, but somehow, we had to put him in the witness protection program, by the way. But somehow, I don't know how the guys got to him, and he left the program, and then he came back and told me, sorry, I'm not able to come and testify. And of course, you know what happened. I lost the case, and it was really, really sad because the evidence was really overwhelming. So what am I saying to us as media today? That since you're usually first respondent on the ground sometimes, if you could just come through and be able to assist us with giving us that evidence, then that would be really important in terms of proving our cases, so that next time when you're asking for conviction, you can put me to task knowing that you played your role as a media person or any other person who witnessed what happened. So of course, numerous applications. I don't want to talk much about it because I know there's a specific topic on it by my colleague. But, you know, I can again give you an example of a case we started in 2019. Up to date, we haven't been able to start the witness hearing, or rather the hearing of the substantive hearing of the case, because from 2019, we've had cases from the lower court to the high court, to the Court of Appeal, to the Supreme Court, and then back to the lower court. So you see there's too many applications coming in, but we are not complaining, because then we are saying that we recognize that the accused persons have their right, and they have the right to make as many applications as they can to be able to defend themselves. Then security of the officers. Some of the cases we are handling are very sensitive, complex, and high stakes, and sometimes we are not as safe as we think. And thank God that through, again, DPP, some of us have been able to get security whenever it is required, so that we are able to efficiently prosecute the cases. And then the final one is international cooperation. The process itself is very lengthy. So by the time you start the, even if I was just to give the example of the extradition, the one we had, by the time the file moves from the Attorney General's office to the DPP's office, then we make the request, then it goes back, you know, and then it goes to the Attorney General's office on the other side. So basically, we are saying international cooperation, it's a little bit of a challenge. It takes long. And then we have some countries that don't extradite or are not willing to also share the information whenever it's required, or it's not shared in real time. So what am I saying as a conclusion? As conclusion, we are saying that in prosecution, we must have a holistic approach. We must have the prevention side of it, that is whenever we can. And then when it comes to prosecution, we must have the witnesses coming in to testify, the courts giving the fair verdict, and everybody playing a role, including us who are here. So the witnesses must come forth, the judiciary must be ready, the prosecutions must be ready, the defense must be ready. The community must also come forth and be able to give evidence whenever called upon. And the most important, the persons who are represented here must also be able to disseminate that information, and where possible, bring in that evidence so that we can be able to prosecute efficiently and effectively. So with that, I've just given you a summary of what we do, our structure, and some of the achievements in terms of the 21st century prosecutions, and also the challenges and how we've dealt with the challenges. Thank you so much for listening to me.
Thank you.
So before that, I'd like because I mentioned the Excellence Charter, I'd like Mike to play the Excellence Charter because it's really what is giving us a way forward from 2020 to 2023, so that when you come to ask those questions, then you have a document that you can start asking from as a reference guide. You can put it to task that you put it in your Excellence Charter, you're going to do it, and you're not doing it. Mike, please. Thank you.
The Excellence Charter identifies 6 strategic commitments who facilitate realization ya goals zetu by injecting accountability, transparency, the excellence, confidence, and quality control into all our operations. Hizi commitments zimeundwa kulete fundamental reforms within the ODPP over the next 3 years. The aim of the charter is to transform the ODPP into a prosecution service yenye ni responsive kwa needs za Wanjiko. The charter adopts a 3-pronged approach, that is, recasting, retooling, and relearning. For recasting strategy, the Excellence Charter identifies 6 strategic commitments who facilitate realization ya goals zetu by injecting accountability, transparency, public confidence, and quality control into all our operations. Hizi commitments zimeundwa kulete fundamental reforms within the ODPP over the next 3 years. The aim of the charter is to transform the ODPP into a prosecution service yenye ni responsive kwa needs za Wanjiko. The charter adopts a 3-pronged approach, that is, recasting, retooling, and relearning. For recasting strategy, the ODPP embraces a 3C approach of collaboration, cooperation, and coordination with both internal and external stakeholders in the criminal justice sector. The retooling strategy hufocus kufanya the ODPP ikuwe rada safi. And lastly, the relearning strategy hufocus kupea staff skills muhimu za kudeliver mandate ya the ODPP. The 6 strategic commitments zitatusaidia kutimiza wajibu wetu. Hizi commitments ni 1. Independence and integrity. Hii husisitiza jukumu kuu la the ODPP la kuheshimu the constitutional independence with fidelity and courage. 2. Lifelong learning. Hii hufocus kupea staff skills muhimu za kudeliver mandate na kuadapt international best practices within the country, hence the establishment of the Prosecutions Training Institute. 3. Reshaping prosecutions. Hii hudai kumodernize prosecution kwa kufocus on the fight against corruption na achieving excellence in complex litigation and emerging crimes. 4. Leadership. Leadership huwa kwa level zote za hii organization. Hii ofisi ita-adopt a servant leadership philosophy, establish a leadership bureau na mentoring initiatives. 5. Organizational effectiveness. Hii hufocus on strategic communication, responsive organizational structure, and delivering of quality prosecutions and performance management. And lastly, 6. Interagency networks. He who focus on reshaping our operations in collaboration with our external stakeholders. We recognize the importance of monitoring, evaluation, and reporting in the achievement of our objectives. Kwa hivyo, kutakuwa na monitoring and evaluation framework and performance management system yenye imedesigniwa kuensure actual performance is measured against agreed targets. Na itaendelea ivo. Wadau, subscribe. Muhimu jo, ndio mkwe rada. Tunaahidi mashtaka yenye haki na usawa.
Thank you very much, Zawadi and Lillian, for that brief but very detailed and distinct overview of what the ODPP looks like. Now that we have an understanding of who we are, it is now time to get to know what is it that we do. And to that end, it's my honor to welcome our Deputy Director, in charge of County Affairs and Prosecution Services, Mr. Victor Mule, to come and take us through the decision to charge process, which is a core mandate, isn't it? Bwana Mule, karibu. In yangu. Ile microphone, iko microphone. Because you cannot hold this on the hand.
Hassan, and welcome our partners on the other side, that is the Fourth Estate, to today's forum. From morning, you have been told about the role of the DPP that is making the decision to charge. This is one of the most important decisions made by a prosecutor. And I used to start by saying that when making the decision to charge, a prosecutor does not just wake up one day and say, I'm going to make this decision in this file. We have the laws to follow, we have guidelines, and we have policies which are in place. And I also wish to state that there are different players. You can just remove this one for me. I also want to say that there are different players in the criminal justice sector. Each player, by way of an institution or agency, has got roles to play, and we insist that each institution plays their role, keeps their lane, so that we can have a rule of law and a structured way of doing things. The other thing I also wish to say that as an ODPP, in making the decision to charge, we are guided by laws, starting with the Constitution, then the Penal Code, the Evidence Act, and many other laws which create offenses. And all these statutes which create offenses establish essential ingredients of those particular offenses. And before any case goes to court, the prosecutor must be satisfied that the essential ingredients of that offense are demonstrated by the evidence which has been gathered by the investigating agency. For instance, if it is murder, you don't just wake up and say, yes, this person was killed by this person. There must be what we call malice aforethought, the intention to kill. If there is no intention, then it becomes manslaughter. And again, there can also be a defense by the person. It can be a defense of property or for other legally justifiable cause. So, in addition to these laws, we also have what we call the decision to charge guidelines. It's a document which is available online. You are at liberty to download it. And it gives the prosecutor guidelines on what to consider. And there are two tests, the evidential test and then the public interest test. The evidential test is all about evidence. And there are 6 parameters, which is the evidence available? Is it there? Do you have a witness who can talk about it? Is it admissible? Is it hearsay? Is it relevant to the case? By relevance, I mean, does it demonstrate or satisfy the essential ingredients? Is it credible, or is this just someone who has brought a case or a complaint just to settle some scores? So that is under the evidential test. Under the public interest test, that is what, as you have seen, is what is good for the public. And this is derived from Article 157 of the Constitution. So when we are considering public interest tests, it's not us who are just saying this one is favorable to the public or this one is in accordance with the law. No, it is there under the Constitution, the public interest test. So today I'm not going to give you a lecture on all these, the laws, the contents of the guidelines to charge. I'm going to talk to you about our experience, the impact of all these guidelines and all these laws in making the decision to charge. What is it that we have learned, and what has it had on the community? And the first impact or experience we've had is that we have had quality prosecutions. And by quality prosecutions, we mean the whole prosecution process from the time the decision is made, the right person is charged with the offense. For the right person is charged with the right offenses. We don't have a person charged with an offense, maybe assault. He should have been charged with another offense, or a person charged with stealing, he should have been charged with forgery. So that's what we are saying. So we have had quality prosecutions from the time the decision is made up to the conclusion of the case, and all this is provided for in the guidelines. And so we have achieved the main objective, which is effective and efficient prosecutions. We have data from our reports from 2017, 2018 financial year, and then 2018-2019, 2018-2019, and then immediately after we started implementing the decision to charge guidelines in 2020, we have data, and we have seen a steady rise in our conviction rate and a steady decrease in our acquittal rate. So it's a positive impact which we have seen, and this is data which is available. Remember, the office is accountable to the public. We have reports which we submit to the National Assembly, reports we submit to the President, and this is in accordance with the law, and this is evidence which is from statistics. We are not just talking about it. We also have through the guidelines cases taking less time in court, because at the time of making the decision to charge, the right person is charged and for the right offenses, such that when the case starts, there are no adjournments. The case, there is a steady flow of the proceedings, and you don't hear the adjournments being requested for by the prosecution. We also, through these guidelines, have been able to ensure that the rights of suspects and accused persons are upheld. Remember, there is the right of fair trial by suspects and accused persons under the Constitution. So this has had the right impact because there is disclosure of evidence at the earliest time possible. There are no adjournments, and the case proceeds expeditiously. The other impact is uniformity and consistency in making decisions. What am I saying? I'm saying if a prosecutor in Lamu is given a file, and the same file is given to a prosecutor in Busia, and they are told to read this file and come up with a decision, they will come with the same decision. Either prosecute or don't prosecute. So there is consistency, there is uniformity, and there is also predictability. If an investigating officer is presenting an inquiry file to a prosecutor, they know or they can predict that this decision will be made because they have covered these areas or they have not covered them. So there is predictability such that the parties are comfortable. There are more, I've talked about more convictions, less acquittals, and they are in the reports which are available online. And through these guidelines, we are able to make independent and fair decisions. These guidelines provide guidelines on what the prosecutor considers, and I've talked about the evidential test and the public interest test. And there is also independence because a prosecutor cannot be influenced by his superiors. He cannot be influenced by investigators. He cannot be influenced by persons who have got influence in the society, because there are guidelines which must be followed. And I wish to confirm that no prosecutor is influenced in the decision they make. They make independent, fair decisions, and there is no impartiality, because the guidelines also provide for disclosure of conflict of interest. Either this is a relative or this is a matter which I cannot handle for one reason or the other. There is also accountability. How is there accountability? The guidelines provide for recording and documentation of any activity or any decision made in any inquiry file. So we are accountable. If the file is taken over by a different officer in the prosecution office or any person outside the office, they know what was done. So the person who made that decision or took a specific action in a file, recorded, it is on record, and there is accountability on the decision. And so there is fair administrative action. You know that fair administrative action is a right under the Constitution. And so the right decisions are made. The right person is prosecuted. The innocent person is not prosecuted. And the person who is to be prosecuted is prosecuted for the right offenses. So those are basically some of our experiences. Of course, we have had negative publicity from the public because of maybe perception, institutions or individuals not appreciating what role the ODPP plays. So our role is we get the evidence from the investigating agencies, and there are very many. It could be the EACC, it could be the National Police Service through the DCI. And once the file gets to the prosecutor studies the file and then makes the decision. The decision to charge is bestowed upon the office of the DPP and the DPP and its officers to the exclusion of all other agencies in the criminal justice system. That is in the law. There has been attempts by agencies or individuals to file cases or make the decision, but that is against the Constitution. We have not just come up to say that this is bestowed upon us by the Constitution. And so those are some of our experiences, and we, as Lillian has said, we have a lot of challenges, and that's why sometimes we have delays in cases. And the first challenge, which I can talk about, is constitutional references. Constitutional references. In almost of the high-profile cases, an advocate will go to court and say our rights or the rights of the suspects have been violated. Once they get orders of stay, they go to slumber, and the case drags on and on in court. The other one is applications for adjournment by defense counsel. And some of these applications are on grounds which are very flimsy. The other day we had an advocate saying, I have COVID, so I can't come to this for the hearing of this case. But the next day he was in another case because we know that other client in the other case was paying better, he was influential, and you guys were covering it, so you would wish to get publicity. So we also have uncooperative investigating agencies. Some who do not avail investigation files in court, others who do not avail witnesses out of laxity or for some reason, some of them bordering on integrity. And so the case drags on and on in court. But using the guidelines now, we have a provision for what we call a prosecution file, such that when the prosecutor is presented with a police file, they make a copy of their file, such that they can conduct witnesses and they can conduct cases because the evidence is already with them, such that if the file is not availed by the investigating agency, they can still proceed with the case. And we have had good positive returns on these. Staff levels. Of course, one of the reasons why we have shortage of staff is because the judiciary is expanding very fast. They are employing more magistrates, but not at the same rate as our office. There are also natural causes like death, and we also have young professionals who are looking for better pastures out there, and they are moving. And it is their right because they are young professionals, and you cannot stop them from moving. And then there is also the capacity to handle very complex cases which drag on in court. And also, of course, Lillian has talked about shortfalls in the legislation, like where officers stay in office after they are charged. That way they are able to influence the witnesses. Like governors, for instance, they are the CEO, so they decide what happens in the counties. They're in charge of the staff. The staff are witnesses in our cases. They feel intimidated. They will not come and testify against them. So that's my short presentation on the impact of the decision to charge guidelines and what influences a prosecutor in making the decision to charge. Thank you very much.
Asante sana Mr. Mule. The guidelines are on our website, I believe, and therefore you can easily access them. Now we have a bit of time. Sasa umefika wakati wa kiulizo. Let's have a question and answer session with respect to what we have heard so far since the day started. Wapi ile hiyo? Sorry. Please mtu atembeze hiyo microphone. Bado tuko gangari ama tunasikia usingizi? Hussein, that men women thing maybe. Huh? Yes. Now, nimeona mkono hapa. Leta hiyo hapa. Hapa. Speakers. Kujibu maswali. Sorry, sir.
Good afternoon once again. Lillian, you spoke about intimidation and gave an example of what happened. How intense are these incidences? And would it be useful, in your opinion, if you shared with the media when they happen? Because that could also be a form of protection.
Three questions, and then we will allow our people to answer. And if you have any questions for the Honorable DPP, please, you can direct the questions to him.
Thank you. Good afternoon. I have two. Sorry, I have two questions. One is for Lillian, and the other one is for Mule. For Lillian, could you kindly expound more on the proposal to abolish the cash bail, and when will it will apply where? And for Mule, could you kindly expound more on the drafting of the charge sheet as far as this decision to charge is concerned? Because I understand at the moment the police are still insisting that they want to draft the charge sheet and bring it to the office of the DPP early morning. Thank you.
Thank you. Thank you for that question. Wacha tupatie akina mama nafasi kidogo.
Okay, I think I have most of the questions have been asked, but Lillian, you talked about the legal challenges and you cited that section of the Act. So how is the office of the DPP addressing some of the legal challenges? Have you sent maybe proposals to Parliament? And if yes, at what stage? And then there is the issue of international cooperation, where you say that you put a request to the AG's office, it comes back to the DPP's office, then it goes to the AG of the country that you need to extradite somebody. So how best can we go through this? Because I know there are countries that are friendly, and because you have cooperations, and just when we saw the DPP Uganda talking, I think there are also the regional countries that work together. And then the other one is the decision to charge. Mr. Mule, maybe just expound on the issue of the conflict of interest. At what point do you identify that there is conflict of interest for somebody to excuse themselves from the case and proceed without them?
Thank you. Thank you, Roslyn. Please, let's have one more question, and then we allow our speakers to answer. And for those of you perhaps who may wish maybe to put it in writing, because you're editors, maybe some of you are not very good at speaking, but you are excellent in writing. You can write those questions, and then you can bring them forward.
Good afternoon once again. I think my question is directed to the DPP, and it's almost similar to what my colleague Francis Mreed had raised. The issue of the discretion on whether to charge or not to charge and also the discretion on whether to withdraw the charges or proceed with the case. What are some of the bases that makes those decisions? And this has also been cited by the DCI and the police as the main source of the conflict between your office and his office, where you have been accused of misusing that discretion. Selectively identify the cases that you proceed with the charging and some cases that we withdraw before they go further. And why is it that your office never discloses the reasons why such cases, decisions are taken?
Thank you, Chris. Sir, would you like to answer him now? All right. Okay, hiyo ya mwisho. Hiyo kiulizo ya mwisho. Alafu tuwapatie nafasi wa
Okay, it wasn't me. Let me just ask and then I'll give it to him. I'm referring to the presentation by Lillian, and I would like to know what approach you will take vis-a-vis our sons and daughters who have been burning schools and they're now in courts. What approach are we going to use?
Asante, Millicent. Mr. Mule and Lillian.
Can this question, as the Honorable DPP answers, can also answer this particular one? Can you allow me to ask the question? Thank you. My question goes to Honorable DPP. I speak wearing two hats. I'm both an editor and I'm also a legal counsel. So I understand the issue of decision to charge or not to charge. However, I think we must also appreciate that the meaning of the term rule of law means that like cases be treated alike. Now, we have had cases, let's say what my friend Victor has talked about, Mule, the decision, the public interest test and the evidential test that a case must meet. But the question is, how comes that some cases investigated by the same investigative agencies have been brought before the DPP? They either have got similar tests, public and evidential tests, but you choose to prosecute some and you don't prosecute some. I think that is the problem, that's the jittery that's within the legal fraternity, because you find that these are like cases, similar, but you choose one and leave the other one. So the question is, where do you draw the line between similar cases, but you choose one to prosecute and the other one you don't? Maybe that's the clarification that Honorable DPP will make further. Thank you.
Asante sana, Hassan.
Let me jump the queue and deal with that before, because the way it has been framed, I want to take you to task. Maybe you can give us an example of those cases, please, so that I can answer.
I think the elephant in the room.
Usiniambie mambo ya Golden Bag na Anglo Leasing. You say the one.
No. Hello. I think the elephant in the room has been the decision over to charge the Honorable Justice Sankale.
I'm surprised because you said you're a legal counsel. You know that matter is before court. And you know why, what's his name, has rushed to court, Omari. Sasa ukiniuliza hiyo question na unajua siwezi kukujibu sahi, it's not fair. So we will have another session when all those matters have been dealt with so that I can come and explain. But the decision to charge is based on whether there is evidence, sufficient evidence for us to be able to move to court and convict. In addition, of course, if you're a legal person, I think Zhao is also, you know that criminal matters we must be able to prove beyond reasonable doubt. If we don't have that evidence, I shall simply not go to court. I think it was explained here what public interest is, and public interest is not what the public wants. Or how the public has been rallied to want something in particular. No. There must be evidence. If the evidence is not there, we give reasons. And if you ask, we are at liberty and we will give you the reasons that we have given to the various investigating arms. Whether it is the DCI, the ESCC, the KRA, KWS, there are so many of them who are investigating, and they bring, and we have detailed briefs. Detailed briefs. And probably I will ask at some point Hassan here, because he's the closest office, to bring some of the briefs for you to look at. We have very elaborate ways of doing our briefs, giving reasons, and presenting those reasons to the investigators. And even assisting them and directing them on how to cover some certain areas where we feel if more is put into it, the evidence will be sufficient for us to prosecute. I hope I've been able to exhaust that particular question. The question of, again, the discretion to charge that was asked by my colleague from the people. And I really wish you would be asking us those questions before naenda kuandika so that we can be able to answer instead of waiting for these sessions. Because people wanatugonga sana, lakini it's okay. Sisi huwa tunakuanga tu tayari. You know, the issue of the discretion. Discretion depends on the integrity of an individual. And discretion does not only apply to prosecutors, it applies to the judiciary. It also applies to the investigators, because they also have the discretion to start investigations or not, based on what information they've been given. That you cannot pin it down to a particular person unless you can be able to prove that that particular person was biased or had interest. And that's why I think when Mule stood up here and talked about issues of recusing yourself, it's where we expect that if you have an interest or you have something to do with that file, then you will step back and say, I'm not going to deal with this, and I'll give it to somebody else. But discretion is really based on issues of integrity. and that can sometimes be very difficult to police. However, as ODPP, we have the inspectorate unit that is there that oversights and reviews the discretions that are done by prosecutors. But in addition, you know, the system itself, the way the Constitution has laid out the justice system, the criminal justice system, it has brought a series of oversight within the system itself. So investigators will go and investigate, present a file. You have a stage whereby now prosecutors come and look at the file and then decide whether that file has sufficient evidence or not. And it doesn't end there. You have to go to court. The court then also applies its discretion, listens to the case and decides whether there is sufficient evidence now to put that person in incarceration. So the system itself has checks and balances to ensure that as ODPP, we are not abusing that discretion. In addition, if somebody is disgruntled, you have a judicial review and also administrative reviews that can be taken. You can go to the ombudsman if you feel maybe the complaints commission within ODPP is not sufficient or you feel it is biased. If you're not satisfied, you can go to court. Several people have done that. And they can ask for the judiciary to review those decisions. So it is not ultimate as in that, you know, we will just go scot-free. You have avenues that you can follow to ensure that what we have done is right. In addition, there is private prosecutions that you can pursue if you want. Nobody has refused that. If somebody is really disgruntled, they can go to court, apply. If we feel strongly that we have dealt with that file, we will go to court and present our case and say, no, we have dealt with it. This will be like a double jeopardy. We don't need to go through. But at the end, the judiciary that is independent will make that decision, not the ODPP. And in several occasions, the courts have told us you have to prosecute, and we go and prosecute, even though we have said no. We follow and adhere to court orders. So, you know, the checks and balances are there. What we are trying to do as ODPP, really, is to bring the Constitution to life. The Constitution is very clear that it has separated the various roles within three different institutions of the government. You have investigators that fall under the National Police Service and other investigative bodies like the ESCC. You have even KRA, who have police officers working with them. You have KWS. You have even for NEMA. They are able to investigate. Then the Constitution is clear that ODPP will have the state powers to prosecute. And it would be very good for you guys to look at the definition of state. What does state mean? State is different from government. State is fixed. It is our boundaries. It is Kenya that will always be there. And government is the political wing of it that changes every now and then. Maybe after every cycle of every 5 or 10 years. So the Constitution is very clear that the state powers to prosecute is with the ODPP. But it also says that Parliament can delegate those powers. But still, even with that delegation, if you look at the various legislation, including the ODPP and the Criminal Procedure Code, they still have to they are still subjected to the ODPP. And as ODPP, what we have done for us in the interest of ensuring that there is uniformity in the decision to charge, we have come with delegated powers, guidelines on delegated powers, and how each institution that wants to practice or wants to be able to prosecute, what they will be required to do. They'll be required to have similar prosecutors as ODPP. They'll be required to do the similar trainings to ODPP within the Prosecution Training Institute. And with that, we are able then to ensure that there is a certain standard across Kenya in terms of the decision to charge, so that when you go, you are certain that a certain decision will be arrived at, whether you go to the ODPP or any other prosecution, any other delegated prosecution institution that could be there, like KRA. So we have tried our best to ensure that we put in place oversight mechanism to safeguard against misuse of these powers of prosecution. I hope with that I've been able to answer you. The other questions, Simutajibu.
Thank you very much, sir. I'm sure ile cobwebs ilikuwa iko Mr. Hassan imetoka sasa. Si ndio?
Thank you. Drafting of charges. Who should draft? Outrightly, the responsibility of drafting charges is bestowed on the prosecutor, not the investigator. The investigator on the investigating agency can recommend charges, but the DPP and ODPP staff are not bound at all. We can drop, we can add more counts and more charges. So the responsibility, the law is clear. Although somebody said, don't say the law is clear because you would not be differing. So the law is there, it is the DPP. And in fact, I wish to bring to the attention of this forum that we are soon going to gazette an ODPP charge sheet. A charge sheet specifically designed by the office of the DPP, which we are going to gazette and which shall henceforth be used. And it is provided for under the guidelines on the decision to charge, which I've been talking about. At what time do you identify and declare a conflict of interest? At the earliest time. Once you identify, you are supposed, once you identify a likelihood of conflict of interest, you are supposed to down your tools at that time, record that interest, and pass over the file to the supervisor for accountability purposes. And we also receive complaints from victims of crime, complainants and their families that this prosecutor should not handle this matter for this reason. And if the reasons are sound, if the reasons are reasonable, the prosecutor is requested to recuse themselves. I think the DPP has answered why are some cases prosecuted while others are not. I think that answer is sufficient. But remember, if a case fails to meet the standard of a reasonable prospect of a conviction, you can be sure it will not pass to court. If it does not pass that test, a reasonable prospect of a conviction, if a court is not likely to pass a verdict of guilt, it will not pass. And this is caused by lack of evidence. In some cases, which I will not quote because they are in court, we count the word suspicion. An IO, an investigating officer, saying 6 times in a covering report, it is suspected 6 times. Suspicion alone, however strong, cannot form the basis of a conviction. And so that case does not pass. I will not quote the case, but that is my answer to that question. Thank you very much. Yes, we are replacing the police charge sheet. We are going to have an ODPP charge sheet, which once you present the file, we select the charges and we type them and we sign in accordance with the law and present before court. So what happens?
The police investigate, then hand over everything to you.
Yes, and they can recommend if they so wish. And that's what is happening. And that's what is even happening with other investigating agencies. They recommend, but we are not bound. And that is essentially what should be happening. Yeah. And the police charge sheet, we have what we call the service standing orders formulated by the National Police Service. And it's based on that, and the service standing orders are not law. It's not a statute. So it's not binding. And that's where they get it from.
Thank you. Khalid, would you please allow maybe, so that she doesn't lose sight of what the questions were all about, let's allow briefly Lillian to respond. Thank you.
Thank you. Thank you, because I had a number of questions. Let me stand here so that I can be able to attempt to answer them. And the first one is on why are we not informing the media about the intimidation? So let me go back to that story I was telling you. That particular witness who was threatened, the same character, if I may use that word, also called me. And it was a Saturday afternoon, and I really panicked. So what did I do? I quickly called the DPP then, and he told me, come to the office on Monday and let's deal with it. So Monday I got to his office, and what does he tell me? Do a letter and let's dramatize this thing. So I was like, okay, so after dramatizing, what happens? And then I remembered I live in a community. And in that community, there are supporters of such characters. So at the end of the day, you weigh, do you want to dramatize that a witness has been intimidated, which of course then you endanger the life of that witness more? Or should you quietly go to the witness protection and ensure that that witness is protected? So, Rosalind, whereas media plays a very critical role, I think when it comes to witnesses that are under protection, I think it's better they're protected chini ya maji so that nobody gets to know who they are, and so that we are able to proceed with our cases efficiently and effectively. So then the other issue is the issue of cash bail. Sorry, from where I come from. And there's been so many numerous reports that we are somehow criminalizing poverty. That if you're poor, then you're not able to pass through the criminal justice system fairly. And this, to an extent, is supported by the issues telling you people are not able to pay bail. So we also did a study in other jurisdictions like the US. I know that some of the counties there have already started outlawing cash bail, so that if you have committed an offense, then they go and do what they're calling threat assessment. Are you a threat to the society? If you're not a threat to the society, are you able to come to court and testify? Then they're able to use that systems to be able to ensure that you're still able to comply with the court terms, you're able to come to court and proceed with your matter for hearing. So this is an issue still under discussions. It's an issue, I think, that is on the table of the NCAJ, and we are hoping that they will be able to buy into this proposal so that when you are charged, you're not locked in because you're not able to afford the cash bail, but you're locked in because you deserve to be in. So then there was the other issue of legal challenges. Yes, we have addressed most of these issues and presented them, some of them to JLAC, and there are other considerations alongside other NCAJ, our NCAJ counterparts. And then on the issue of the MLA, let me explain how it works. The MLA works by the other countries sending a request to the Minister of Foreign Affairs, which then sends it to the Attorney General's office, which then cascades it down to the ODPP. And if it's for us to action, then we'll action it. If it's not for us to action, we'll perhaps look out for the investigating officer who will then action. And then it comes back to, then once we finish with it, then again it goes to the Attorney General, who then takes it to the MFA. Then if it was us who was requesting in this case, then they then get to the Attorney General or the DPP in that country, and vice versa. So that's why we are saying it's a challenge, because it's a process that must be followed, and it's internationally recognized. But what we've done is also to create informal networks. That is what the DPP of Uganda was alluding to, such that if there's a case, then the DPP Kenya is quickly able to reach the DPP Uganda and informally begin the proceedings. But legally, for that evidence to be admitted, it must go through that formal channel that is recognized. Then the other issue that was raised was the issue of banning of schools. How do we deal with such children? So from experience, I know we had Changuli case, I think about 2000, and there about 2000, I think maybe 2002. And we were able to prosecute the boys for banning the school. And also the Moi girls, I know it's at the advanced stage, the judgment stage. So whereas we are trying to give a second chance to the children, to our children in this case, but there are also certain values that are expected from them that must start with us as parents. So my answer would be, it would be holistic or multi-pronged, right from us, the parents, to the teachers, to the school itself, and also to the criminal justice system, so that we do not come up with children that are ungovernable, because they are our future. But what we are saying, that depending on the circumstances of the case, then once they've gone through the system, we will be able, as an office, probably to allocate mentors to work with them so that they are reformed. But they must go through the criminal justice system if they have committed such heinous crimes. I think I stopped there, only to add that the reason why we are all talking about decision to charge is to really see how it is benefiting. And I know some of us here, they brought for us one piece of paper and told us we charge, but we were not able to because there was no evidence. So we are seeing that decision to charge has an impact because you are actually charging those who deserve to be charged, and it's just not like passing the roll or ticking or checking the boxes. So it has an impact.
I just want to add on that issue of extradition and MLA. I think the Supreme Court was very clear, because I don't want us to go and then make another, then maybe you didn't understand what the Supreme Court said. The Supreme Court simply said the work of the Office of the Attorney General is to receive from the requester and to deliver to the ODPP. So kazi yao ni kudeliver. They have no other role in that issue. And once we are done, we give it to them to then deliver it to the recipient, the country that made the request. Historically, and this could either end to the DPP or the other country depending on the jurisdiction. Historically, the office of the ODPP was under the Attorney General, as you all know. And the Attorney General was the DPP himself. Then you had people like Chunga, who were the Deputy Directors of Public Prosecutions. They were not Director of Public Prosecutions, but Deputy Directors. And they would run that office of the ODPP. But the DPP himself was the Attorney General. Hence, in some jurisdictions, like in the UK, where you still have the Attorney General who doubles up as the DPP, then you will see that the Attorney General is the one making the application to the Foreign Office, and it goes like that. So in our case, for example, if we want some evidence from the UK, then we will make that application, and then it will go through to the office, to the Ministry of Foreign Affairs, who will then deliver it to if it is to the UK. And I think there will be a lady tomorrow called Shamini, who will be here from the Crown Prosecution Services. They will then receive and now start acting on it, and then return it in that manner. The Constitution, and this now is because the new Constitution is very clear that all criminal matters are under the purview of the Office of the Director of Public Prosecutions, and any applications on any criminal matters will have to be dealt with by the Office of by the Office of the Director of Public Prosecution, whose office is independent of any other offices. So do not confuse and think that the Office of the Attorney General can direct the Office of the Director of Public Prosecutions. No. They are only transmitting from one to the other. And this is, I think the Supreme Court was very clear that it is historical and it will remain as such. Thank you.
Thank you very much, sir. Mr. Hussein, I think you had a burning question.
Thank you. It's not burning, it's just a question. And mine is directed to the Deputy DPP, Mr. Mule. Can a decision to charge be rescinded? That you've checked your policies and you've confirmed that you're going to charge, but then review that decision and decide not to charge? Is that possible?
That is quite possible. It is provided for under the guidelines, and there are many reasons why we review. We can review even before it goes to court. We can even review when the case is already in court, the accused person has taken plea. Circumstances do change. The complainant might decide to withdraw. We might get evidence which now waters down the prosecution case, which evidence was not available at the time of making the decision to charge, and such like reasons. So there is provision for review, and that power, that responsibility is bestowed upon the DPP.
Maybe I can expound on that. Again, it's not peculiar to us. You know very well in the US and in other jurisdictions, there has been also miscarriage of justice. We have to be frank. Sometimes as humans, we can make errors. But when it comes to our attention, then we have to review. If additional evidence is stable, for example, that changes the substance of the case, then yes, we have to review it and withdraw. But the reason why we have the decision to charge is to try as much as possible to minimize such incidences. And that's what we are saying. Instead of us just rushing to court, we rush to court and charge, and then you don't have, you didn't get everything, you didn't give the opportunity to have a look at it thoroughly and ask the questions, the hard questions that are meant to be asked, and insist to have all the documents. So that, as Mule said, it's not a matter of we are acting on suspicions. The reason why we are having this decision to charge is to minimize such incidences, so that we move when we are ready, and we make that decision with as much evidence as possible within all the evidence. So yes, we can review at any stage, and that's why even in the Constitution you have various steps that addresses this issue.
Okay,
Sorry.
just sorry, I don't want to
Thank you,
engage in a conversation, but can those decisions then be communicated to the parties? And I'm specifically making reference to the Busia case, where over 20 police officers were supposed to be charged, and we were even in court. And then at the last minute, the 11th hour, the DPP withdrew the case. To date, the victims do not understand, and there's no communication why the matter was withdrawn. I understand new information might have come to your attention, and that led to that decision. In the minimum, we should communicate that, ABCD came to our attention, and this is why this new decision or the rescinding of that decision has been made.
Yes, that is something that can be shared if the request is made. But do you have comments on that case? Yes.
I know that case, the one for Bugoma, the one for 21 police officers. Yes, a request was, we made the decision, but we reviewed it. But we communicated in a very detailed, recent letter the persons to be charged, the persons who bore the highest responsibility. I don't know why it has not. We communicated to the police. Yeah, and we can provide the information if requested. So there was detailed, recent communication for the review, and it is in writing.
Thank you very much, sir and Mr. Mule. Dennis, you have a question?
Yes, I do. I have several, but because of time, I'll maybe just stick to one for now, and the rest will come maybe in the other sessions. Lillian has been making reference of witness protection. PEV gave us a classic example of the gaps that exist when it comes to witness protection. My question is, what are the capacity gaps in implementing within your framework the protection program? It's never been very clear in the country. And what are the underlying issues and also include the issue of funding. I don't know whether this is Lillian who will address this, but it's been a serious issue because when you have witnesses who are supposed to go to court and they're facing serious crime offenders, there have been gaps. It's not been very, very clear to many people why these gaps exist, whether it's a legislative issue or what are the existing issues. So maybe you can just respond to that, and then the other questions will come later because of time. Thank you. Yes, yes.
Okay, no, I think it's simple because witness protection doesn't fall under us. It's a semi-autonomous institution and autonomous, actually, I think, autonomous institution, but under the Office of the Attorney General. Of course, its work has an impact on us because when we have vulnerable witnesses, then we want them to provide the services. It's still a very young institution. And I think a young concept. Actually, I think probably the only one probably in sub-Saharan Africa. But it has, and I don't want to speak on behalf, we sit on the board as ODPP. It has its challenges in terms of the amount of funding that it gets. But it's something that is gradually being addressed. They have, without divulging too much about how they operate, but they have several safe houses where they can keep vulnerable witnesses who are put under the witness protection. It's something that we are going to try and develop as much as possible as a country. But yes, it has quite a number of challenges.
Sorry, just to make it clear, the reason why I asked is you are conjoined in this program as well. So from your end, what are those capacity issues or gaps that you experience when dealing with witnesses?
The capacity issues are funding, really. If they are well funded, they can provide the requisite services that are required. But the funding is not sufficient. And until it is, we are going to have a lot of teething problems. The officers involved are competent, and there are people that we work very closely with, but we also understand the challenges that they have. Providing witness protection is very heavy in terms of finances and funding, because it means relocating the person, giving them maybe probably a new identity, and all that is supposed to be at the cost of the government, because it is in the government's interest that that person is given that protection. In other countries like the US, you can even be relocated to another country to go and live at the cost of the government. But us as a young country, we have still not reached that stage, but it's something that we aspire to. So there are numerous challenges which are mainly based on funding. Yeah.
Thank you very much, sir. Ruth had raised her hand a little bit earlier, sir. If you can just hold on for a second. We must keep in mind that we have approached the lunch hour, and before perhaps you go on, Ruth, there is a lady or somebody has misplaced a gift bag which has her room keys and a cable for charging her phone. Please, if anyone has come across it, please can you deposit it at the Secretariat's desk. So I don't know how many more minutes we can take because it's lunchtime. And for lunch, ladies and gentlemen, as we go out, we'll be picking the meal cards from where or those desks are.
All right, thank you, Hassan. I'm going to be very brief, and this is a follow-up question to what Lillian presented. It's about protection of journalistic sources. Lillian, I think at some point you did say that, I don't know if the witness bulked out and it was a media person, And that got me thinking about, in the line of our work, protection of our sources is central to the ability of us to properly investigate stories and tell those stories, as well as the individuals and the whistleblowers who sometimes bring that kind of information to us. You sort of were trying to look at how you and the media can work closely in prosecuting cases, and I would like you to just talk a bit about what your office is doing in terms of also protecting and defending our work and ensuring that the kind of material you're saying or footage, or you're saying we are fast at the scene and be able to work closely with you, wouldn't that put journalists at risk and affect the free flow of information? And in terms of admissibility of that kind of evidence, to what extent would you use it? Thank you.
Thank you, Ruth. Doctor, is it? Where is your
Wanyama is my name.
Mr. Wanyama?
Yes.
The floor is yours.
Yes. Just a quick one to the DPP. At what point does your office seek to gag the media? Because there have been attempts, for example, in 2018, your office jointly with the DCI wanted the media not to report on Kenya Power corruption scam. So, one, explain to us why you would want the media not to report on some cases. Two, how does that affect, how for example, like such an order, if you acquired it, how is it supposed to affect the relationship between you and the media? And lastly, comments, for example, on why some high-profile cases, like the one involving Samburu, former Samburu Member of Parliament, Lembruke, who was jailed for slapping a lady. And then one, Evans Kidero, the case just went like that. This man was never prosecuted. Thank you.
Wanyama, I want to believe that you will take the answers and break for lunch. Please, tutachelewa sana. I know we have many questions, but you also have to be alive.
Maybe I'll answer the last one, and then the rest will help me. I really don't recall wanting to gag the media in 2018 on KPLC. I don't recall that. I'm saying I don't recall it. It could be on record. But we hardly do that unless it is something that will affect either the victim or the judgment of the magistrate or the judge. But really, if you look in your records, it's very rare. And maybe very sparse. The only other time we have done this is, of course, the issue of the case of Kantai. And we did that because it was really going to affect the case that is before court, where we had charged the lady. And I don't want to delve into that because it is a gag that is gagging myself and you guys. So I have to be very careful. But there are really reasons as to why we go. Sometimes, and I'm not saying sometimes we're humans, it could also be impulses. But when that is so, as a media, you can bring it out. And we will try to correct ourselves. But there are reasons. In other jurisdictions where you have the jury, it is extremely important to gag the media so that you don't they don't affect the decision of the lay persons who serve as juries. We used to have assessors here, now we don't. From other cases, now we don't. It's the magistrate. So we try and weigh and see whether that information would actually be prejudicial to the prosecution and will affect the decision of the magistrate. And that's when you go for gagging. But we usually outline the reasons in the affidavit and in the applications when we take them to court. So if you read them, you will see the reasons that why we are doing that. And of course, then the discretion lies with the court. Sometimes it will agree, sometimes it will not. Yeah, thank you.
Thank you very much, sir. There was one question, a written question here. Maybe if I can read it, probably this is the last question that we are going to answer.
There's one on Lembruke and Kidero, the slapping instances.
Oh.
Sorry, you see, it also depends on the complainant. And if the file is brought, I can assure you, we will charge. Hiyo ya Lembruke ililetwa. Ya Kidero, wewe utaniambia kama faili ililetwa na nikakataa.
You kept on promising, and it's on record, Bwana.
No,
yes.
I can promise that I will charge when you come and ask me. But it depends on the file. I'll tell you, once the file comes, I'll charge. Kama file akuje mimi nifanya nini? I cannot create a file. And this is one reason why we are here. As ODPP, our mandate is to prosecute. We don't investigate. And we have tried as much as possible not to interfere with investigation, even though the Constitution and the ODPP Act says we can actually interfere and lead. But we have been, if you read our act, and I think when we come back in the afternoon, we will take you through, it is very clear that we can lead investigations, not only instruct, we can actually lead and guide investigations. But we have chose not to do that, purposely so that the separation between the two are clear, that we are going to prosecute. We will suggest to the prosecutors and recommend to them and guide them on what to look for and how to bring the evidence, but we are not involved in investigations. Thank you.
Thank you, sir. Thank you very much. I don't know whether there's any question that is unanswered yet. The one that Ruth asked. Who is going to speak?
So I think, Ruth, if I still remember correctly, you're asking how we can cooperate with media and as to whether that evidence is admissible eventually. And what I can say is that we are indeed having a good relationship with media in terms of we've received various complaints and we've been able to direct the investigators to be able to investigate those cases, especially where the journalists have been harassed. And I was just looking at the statistics I had some times back, and we look like we have about 20 cases that we're following up that we've gotten requests from either the Editors Guild or the Media Council requesting us to follow up and ensure that those cases are investigated. So the other question is whether that evidence is admissible. And my answer is yes. It depends on how it was taken and who took it. And so, for instance, if you're talking about recording, then we'll have to go through the process on how that evidence gets to be admissible. But in a nutshell, yes, that evidence is admissible. Thank you.
Thank you very much, Lillian. Now, there is one question, a written one. Let me just read it. In terms of community prosecutions, as a part of the holistic approach in your work, do you incorporate the indigenous justice system tenets that are in line with our laws? The question is about asking whether we incorporate the indigenous justice system tenets that are in line with our laws. This question has been asked by Mr. Justus Wanzala of KBC.
Okay. I think as NCAJ, there is a committee that has been established by the Chief Justice on alternative justice systems. And this is where we hope to be able to do that, to incorporate some of those, what you're calling community-based systems or customary law, criminal customary law. But first of all, it's something that we will have to document and understand, because we have a lot of different communities in Kenya, over 41. But it's something that we have agreed as NCAJ, the National Council on Administration of Justice, that is chaired by the Honorable Chief Justice, to look into and establish mechanisms of getting into that. I know there is a questions of masla and all that, but as ODPP, we have been very clear that we will not entertain that without a legal framework in place. So at the moment, we are not. Even though we have the issue of plea bargaining and diversion, we have the diversion policy, and really it can be captured there. So if there are petty crimes that can be dealt with wazes na nyumba kumi na nini, that we are accommodative. But when it is murder and sexual-based, cases of violence or gender-based violence, hiyo tumekataa kusikiza mambo ya masla. The last 2-3 months, there have been quite a number of petitions in relation to defilement and rapes that tumekubaliana chini ya miti hivi makesi kuishe, but we are refused. We've also had ridiculous applications also that even in corruption matters tunaweza angalia mambo hii traditional. But it's not possible. So we also have to draw the line. It has to be very clear. There must be policies and there must be a legal framework so that it is not abused. So that's where we are with that. Thank you.
Very much, sir. Mr. Mule, with your permission, sir, I would like to add something.
Yes, on traditional dispute resolution methods, I want to read to you Article 159.3 of the Constitution, which reads, traditional dispute resolution mechanisms shall not be used in a way that A, contravenes the Bill of Rights, 2, is repugnant to justice and morality, or results in outcomes that are repugnant to justice or morality, or are inconsistent with the Constitution or any written law. So those are some of the considerations that the ODPP makes in applying alternative dispute resolution at the traditional methods. Thank you.
Thank you so much. Dr. Nyakundi has a comment to make, and I think after that, Roslyn, si twende tukatafute chakula. Okay. Let's hear what Dr. Nyakundi is saying.
Thank you. Thank you, ODPP and the DPP in particular, for being very open and sharing. But just so that it doesn't remain at this workshop, can you propose to set up a system where this transparency is accessible to journalists? Because if, for example, you decide you're not proceeding with a case, you have explained yourself to the relevant agencies. The journalists or the media that represent the public are not aware of what you've done. You allow them to engage in speculation. So can we have a system, either it's on your website or you set up a media desk, where at every point where you make a decision, especially on the major cases, then this information is readily available. If we go the way of requesting for that information, sometimes it's tricky. People are working against deadlines. Maybe when they need the information, you're also not available to give it. So can you have it in such a way that people can always access? Because what I realize in this conversation is that there is a weak link in terms of communication. There's a lot you are doing, yes, but unless the media knows what you are doing, then you allow them each time to speculate. And I think they are perfectly entitled. So in a way, what I'm trying to suggest is that going forward, because it's not every time you'll be calling the media here. Let's have something that is structured so that each time there is an issue, then the media can easily access this information. Otherwise, hii story ya kugongwa, utaendelea kugongwa tu. Because if the information is not there, then I think media people are allowed also to speculate, to provoke you so that you come out and explain. Thank you.
Asante sana Dr. Nyakundi. Rosalind, please.
Yeah, I think mine is a follow-up to Ruth's question on the issue of journalists being witnesses. I think apart from them having their own cases, when maybe a journalist is working on a story, that you want to have the journalist as a witness, on what are the avenues you have in place to ensure you protect the journalist, and at the same time, they also don't lose confidence with the sources that give them those information.
Thank you, Rosalind. Lillian would respond to that.
So when I look at a journalist is wearing two hats. One as your profession, which comes with certain rights, and secondly as a witness, which therefore means a member of public. So it depends on the hat you're wearing. If you're coming in as a witness, then if there's need for you to be placed under the witness protection, then joint with the witness protection, because the ODPP has an MOU with them, then we can be able to put you in the witness protection. If you're coming in as a journalist, and then we expect you, and I'm hoping this will be discussed tomorrow, if it's not really with regards to the matter before court, to fairly report or even bring that evidence to forth. But I am glad that we are beginning to hear ways on how we can strengthen this journey that has perhaps begun today by coming up with systems where we are able to readily avail information. So I think the journey has begun, and I'm hoping that at the end of the 3 days, we'll come up with a certain way on how we can be able to tackle such issues, subject to the, of course, leadership of the DPP, if it's and your organization and media council, if that is acceptable. So, sorry, I think the message you're sending is that
Can you use the microphone so that the rest can benefit?
Yeah, so the message you're trying to send is that let journalists do their work. Don't turn us into, like, what you're trying to say, like, we collect evidence and then you come for it and you say, can we use this evidence to prosecute a case? And if we get ourselves in such a situation, how do you make us continue doing our work and not lose the trust and confidence of the people that we are going to as sources of stories? Because if I go and film something or get a story or someone gives me a lead, and then that eventually becomes a matter that ends up in court and you're coming to me to ask for footage, because I know that that has happened to various media houses. You put us in a very awkward situation that, yes, I know that I'm serving public duty or interest and all that, but then at the end of the day, I'm a journalist, and that is what feeds me. So let me do my work, then you do your work and look for evidence. That's what I think, that's the message you're trying to pass.
So Ruth, are you saying that when you do an expose, then tunawasumbua baadaye? I'm just trying to understand.
Ufanye kazi yako wewe mwenyewe, uende ukachimbe jinsi nilivyochimba na kufichua na kupata hiyo habari. I think that's what we are trying to. We have brought it to you. Go out and do your role as a the DCI, let them do their work. So don't come to us and say, give us that video or give us that footage, because it makes our sources that we go to for stories sometimes very hesitant to talk to us.
Asante, because nafikiria wewe mwenyewe umesema mwenye utauliza. Because, for us, by the time we give you the story, usually it is the statement that we posted saying, this is the decision we have made to charge. And that's final, because that means we have the evidence and we're in court. But to come to the defense of our colleagues at DCI, you see, in the absence of a complainant, we will be left with no option but to come to you, unfortunately, to give us, either you tell us where that information has come from, so that we can have a complainant and follow up on the story, or you volunteer and work with us to help us get the evidence, because the flip side of that is, of course, mutasema 2-3 weeks later hakuna kitu tumefanya. You see, then it also becomes unfair. So if we can work together and help each other, that will be good. And of course it needs us to be able to build the trust and the rapport. And this is one of the sessions that we are trying to do. Of course, what you said is also very important. For us, our assumption is once we charge and we present to court, then the documents are public and you can get them from the judiciary. But then what we will do now, and this is why we are here, we will take that into consideration, and we were actually developing, and I think there's a lady who will come and explain to you. We're actually developing a website where we will have all the cases. You can be able to go and get as much information as you want, and we will be able to share how we arrived at the decision, and of course some of the communication, because some of the communication we cannot share because it can become prejudicial to us in court in terms of what we've communicated, how we've asked for the evidence, and that can also be negative. But how we've arrived and why we've made a certain decision, that we are working on that to have it on our website and our various platforms, so that you can look at that. We have the ODPP Cafe also. We have tried to do that there. We have also tried to put it in the Twitter and Facebook pages that we have. But we will endeavor now to be more systematic, as you said, to put it out there. The thing is, if we are able to build that trust between us, then we'll be able to work, and you will not have this worry that has developed over the years. Thank you.
Thank you very much, sir. I'm not seeing any other hand raised. That now signifies is that the hunger pants are taking control. So as we go out for lunch, I just want us to think about something. As journalists, for us now, talking maybe as a person who watches TV and newspapers. Now we have these situations where you attend press conferences, and when you sit in the evening to watch the news, you see different versions of that same conference that you have attended. And when you read the newspapers the following day, you wonder whether you attended the same conference. Maybe as before we start our session in the afternoon, we would like to know why is that? Because that is when issues of that I was misquoted and sometimes even rebellious actions can arise. Why is that the situation? Now, as you think about this, you should also think about this public perception that is there. And that is why I think Hassan and Mr. Wanyama probably got sucked into this, because when you read about the newspapers, you form a certain perception. And that perception now tells you the DPP should have done this, or the DPP should not have done this. So now you understand. Because we also want a bit of answer so that we understand. Why is it that we read newspapers and there are different stories? We watch news, different stories, yet you attended the same press conference from Alien Wanjiru, for example. Sawa sawa. So as we go for lunch, please, let's enjoy the lunch. We shall convene at, how many minutes do we need for lunch? Can we say 1 hour? I think we can come back at 2:15. I know we say 2:15, but we'll start trooping in at 3. Please, if it's 2:15, let's try to be at 2:15. Otherwise, I thank you very, very much. I see that we are going to have very robust discussions as we go forward. And hopefully, we will have a very, very, very fruitful outcome. Thank you so much, and enjoy the rest of the day as we wait to come back in the afternoon. In the afternoon session, very quickly, we will have a session on election preparedness, and maybe some of the issues can be canvassed then, because as journalists, what happens if you have attended a rally where you are the only one covering that rally and there is a lot of hate speech going on? Where is that evidence going to come from? And you will be saying, go and arrest this man and he should be charged. Yet you are the sole custodian of that evidence. Tukikuja mchana, tutaongea.